Justice for Our Neighbors as a volunteer. Wanted to tell you a little bit about Justice for Our Neighbors. We first started taking cases here in 2007. We represent primarily immigrants who have some kind of remedy for their undocumented status. So we work with U visas for victims of crime and domestic violence. We do special immigrant juvenile status cases, and then in 2012 started doing DACA, Deferred Action for Childhood Arrivals, with the administrative relief from President Obama. And in a few months, we'll be doing DAPA, Deferred Action for Parental Accountability, again, a new form of release from President Obama. This particular effort is funded by 7 local funders that were then matched by grant makers concerned with immigrants and refugees. And Jfon doesn't do it alone. It's truly a very close collaborative with Conexión Americas and Turk, Tennessee Immigrants and Refugee Rights Coalition, and Camila is here from Turk. And so the 3 organizations work very closely to reach out to as many eligible individuals as possible. One of the hard things is getting out into rural areas, reaching people who do not speak English, and so together with those 3 organizations, we're going to try to reach as many eligible DACA and DAPA recipients as possible. We, of course, couldn't do it without you, and behind you will be a kind of a cadre of non-legal volunteers trying to help organize papers and fill out papers for your review. So thank you very much for being here. We really appreciate it. One other thing, just to tell you a little about Jfon, we've had a little bit of growth here lately. In January 2013, we had 1 employee, Adrian, who you'll hear from next. In January of 2014, we had 2 employees. And in January of 2014, we have 4 employees. So we're growing and hope to continue to grow so we can serve more people. And thank you again for being here.
Thank you, Kathy. All right. So I am Adrienne Kitos. I'm the legal director for Tennessee Justice for Our Neighbors. And you'll be hearing from me and from Bethany Jackson, our DACA attorney, a little bit later. Our goal today is to for you to leave knowing the eligibility requirements of the Deferred Action for Childhood Arrivals program, how to document those requirements, and how to actually prepare and submit an application for that form of relief. Alrighty. So there we go. For a little bit of context, there are a few major ways that a person can immigrate permanently to the United States. Those are through an employer, through family, or through certain humanitarian means. The employment-based process requires generally a person to have an employer willing to sponsor them to come to the United States, a job offer, and depending on their education, training, credentials, there could be a very long wait or a very short wait for how long it takes to actually get through that process. For instance, if you are a Nobel Prize winner, it's a lot quicker in general. The family-based process allows U.S. citizens and permanent residents to petition for certain close family members to come to the United States as permanent residents as well. That process has 2 steps. The first step establishes the relationship and gives you a place in line, and the second step is the actual green card or permanent resident application. The wait between those 2 steps can vary from none at all to very, very long. For instance, the sibling of a U.S. citizen who was born in the Philippines would have had to start this process before July 15th of 1991 in order to actually apply for their green card today. So it can be a very, very lengthy process, depending on your relationship to that U.S. citizen or permanent resident. There are certain humanitarian means to permanent residents, including a U visa for victims of certain serious crimes who cooperate with law enforcement, a T visa for victims of trafficking, special immigrant juvenile status, which is available to children who've been abused, abandoned, or neglected in the United States if a juvenile court determines it's not in that child's best interest to return to their country of origin. Asylum or refugee status for people who face persecution in their home countries. Those are just some of the humanitarian ways that a person can eventually become a permanent resident. Then there are also temporary or non-immigrant statuses, including a student visa, a tourist visa, that allow a person to come for a certain amount of time or a specific purpose to the United States. Once a person has some basis for either immigrating or for applying for a temporary status, we also have to consider whether they're inadmissible to the United States. And grounds of inadmissibility can include prior immigration violations, criminal violations, certain health conditions can affect whether or not a person is admissible to the United States. Now, the DACA program is actually outside of that typical system. We don't have to worry about inadmissibility grounds in the same way with the Deferred Action for Childhood Arrivals program. However, criminal issues in particular are going to be a very important part of this process, determining whether someone has a criminal history that's going to disqualify them from being eligible. As you all seem to have found, you do have slides in your folder, and they're a little bit dark. I apologize for that, but we can email those to you after the training today as well, if that's helpful. So as of July of 2014, only about half of the people who were immediately eligible for the DACA program had submitted applications, and these are the nationwide numbers. So there are a lot of people out there who are potentially eligible for the DACA program, and more age into the program every year. We'll see in just a few moments what those age requirements are. But there are a lot of people who could be eligible for DACA who haven't applied. That may be because of lack of information, lack of counsel to help them with that application, or hesitation because of the limitations of the program, which we'll talk about in just a few moments. In Middle Tennessee, in particular, there's a need for pro bono legal services. Metro Nashville, of all the cities that the Immigration Service has studied, has the lowest approval rate for these DACA applications at 73%. So our hope is that with a trained volunteer and a trained attorney to help those applicants, that acceptance rate or that approval rate will increase. And we estimate that less than half of eligible applicants in Tennessee have submitted those applications. In addition to people who have not submitted initial applications who are eligible for DACA, the program, which began in 2012, initially offered a 2-year grant of the protection. So a lot of the young people who applied at the beginning are now ready to renew that grant of DACA. So there's a whole group of young people who currently have DACA who are going to need to apply to renew it in order to maintain that status. Okay, so what does DACA offer? If you apply for DACA and are approved, what you receive is a 3-year grant of deferred action. That was a 2-year grant of deferred action when the program began, but as part of the executive actions announced on November 20th, that grant of deferred action was increased to 3 years. So anybody with an application pending as of that date or who applied afterward, whether for an initial grant or a renewal of DACA, will receive 3 years of the protection instead of 2. USCIS has said that they're looking into whether it's possible to extend the grants of 2 years that were approved before that date, although we haven't gotten any updates as to whether that's going to be possible as of now. Deferred action is a decision by the government not to pursue removal proceedings against an individual. So basically, it's protection from deportation. It's not a lawful immigration status, the same way that a tourist visa or student visa is, but it does mean that the person is lawfully present in the United States. Now, that lawful presence can be really important if they were to qualify for another form of immigration relief in the future. For instance, to apply through a family member or employer, perhaps. Having lived in the United States with lawful presence, as opposed to unlawful presence, could be a big benefit in those future applications. The other major benefit of the DACA program is that if you can demonstrate financial necessity, an approved applicant can receive an employment authorization document or a work permit. With that work permit, you can get a social security number. You can use it to work. You can also, in Tennessee, use it to get a driver's license. That's true in a lot of states, but not all of them. It may also increase the recipient's options as far as higher education goes. Those kind of things, although there are limits on the types of any public benefits that they would be eligible for, even though they would have a social security number. Okay. So applying for DACA is not without some risk. Basically, what an applicant is doing is sending their information to the government without a means to obtain lawful immigration status at this time. They can get that protection from removal and that work permit, but not a lawful immigration status. This is an administrative program, so there is always the possibility of a change in policy. There are, in fact, a couple of challenges to the policy right now, one legislative and one as a result of a lawsuit that's been joined by the governors of several states, including our own, that asks a judge in Texas to end the DACA program, basically. We were actually just talking with some of the folks from the Tennessee Immigrant and Refugee Rights Coalition. They're an advocacy organization that, that does a lot of work around immigration advocacy here in Tennessee, and their feeling is that a temporary injunction is possible. It could look like a lot of, there could be a lot of different ways that it could come out. It could be very limited or rather broad. We've decided to kind of keep on trucking in the hopes that that if there is a change in the policy, it'll be temporary and limited, and that we can continue working with applicants for the time being. Right now, there's been no decision made regarding that. So that's one of the potential risks. The other is that the applicant is sending information about their immigration history, criminal history, all of that to the government. USCIS policy is that information won't generally be shared for immigration enforcement purposes unless the person meets the criteria for issuance of a notice to appear, which is the immigration charging document that you received if you're placed in removal or deportation proceedings. So that would be someone who's committed serious crime, is a danger to the public safety, is committing fraud in the application, those kind of serious things. So that's one of the very important things that we want to screen for when we're working with applicants, to make sure they're not going to trigger any of those reasons to issue that notice to appear. That information could be shared for other purposes, including criminal law enforcement. So that's another thing that we have to keep in mind when working with somebody who may have a little bit iffier of a history. That policy is in place today, has been in place since the program began, but could change without notice. It doesn't create a substantial right in and of itself. So this is one of the reasons why it's so important for every applicant to have an opportunity to meet with counsel, to understand that, that there are potentially risks to this application process, so that they can understand those and make the best decision for themselves and for their family. Alrighty. So now that we've gone through all that very pleasant stuff, we want to look for just a moment at the requirements for applying for deferred action. So the applicant must have entered the United States before the age of 16. They have to have been under the age of 31 on June 15th, as of June 15th, 2012. That upper age limit is going to be removed as part of the DACA expansion program announced on November 20th, which is right now scheduled to take effect around February 20th. So under the expanded DACA program, there would no longer be a requirement that you were under the age of 31 as of June 15th, 2012. You have to have continuously resided in the United States since June 15th, 2007. That's another change under the expanded program. That date will be bumped up to January 1st, 2010. People who meet the expanded DACA requirements can't apply yet. They have to wait for that new process to come out next month, hopefully. You have to have been physically present in the United States on June 15th, 2012, and when you're applying, you can't have had a lawful immigration status as of June 15th, 2012. You have to meet certain education or military service requirements, and you can't have a significant criminal record, and we'll look at that in a little bit more detail in just a minute. Okay. So the first requirement is that you enter the United States before your 16th birthday. So as long as you initially establish residence in the United States before you turn 16, even if you had left the country after that point, and returned, you still can meet that requirement. So travel outside the United States before June 15th, 2007 wouldn't necessarily affect your eligibility for the program. Even if, say, you came in at the age of 14, lived here for a few years, left, and then when you re-entered, you were 17 years old. So long as you had initially established residence before the age of 16, you could still qualify for the program. And what they'll look at in making that determination is how long you lived here. Did you register for school? Did you work? So in some cases, we have worked with clients who came in at the age of 15 and didn't enroll in school, but instead got a job right away. But basically, did you establish a life here before the age of 16, even if you subsequently traveled outside the country and later returned? You do have to have been continuously resident in the United States since June 15th of 2007. We'll look at a few exceptions to that rule in just a second. You either have to have entered without a lawful immigration status, or if you initially came in with a lawful immigration status, that status must have expired as of June 15th, 2012. The most common way that the clients we work with entered the United States, if it was lawfully, was with a tourist visa, which is generally valid for 6 months from the date of entry. So that's not usually an issue. So because if they entered with a tourist visa before June of 2007 and we're looking at what their status was in June of 2012, then we're easily outside that 6-month bar. Basically, a person should, if they entered lawfully, should have a stamp in their passport or a document that says how long their status lasts, and then that's what you would look at to make that determination. If they had a status like a student visa, that's considered a duration of status, valid as long as they're enrolled in school, then that would not be considered to have expired as of that date unless there was a formal adjudication that it had ended. That hasn't come up for any client that I've worked with, but if you were sitting down with someone and they had a status that said D/S, duration of status, then you could talk with one of the other lawyers to make a determination of whether or not that person would qualify under this requirement. And that June 15th date, I should back up a little. June 15th, 2012 is when the DACA program was announced. That's why that shows up so often. That would have been nice to know. So that's why we have to demonstrate that they were out of lawful status at that point and physically present on that date. They have to be in the United States when they're applying for deferred action, and they can't have left the country without advance parole, basically without permission, since August 15th, 2012, when the actual application became available. Yes?
Is it that the immigration status expired on June 15th, 2012?
It should be 2012. I apologize for that. It should be, June 15th, 2012, no lawful immigration status, not 2007. So the continuous residence requirement, again, under the program as it exists today, and this is going to be bumped up to January 1st, 2010 under the expanded DACA program. But as of today, you have to demonstrate that you were continuously residing in the United States since at least June 15th, 2007. Now, a brief, casual, and innocent departure from the country wouldn't affect that continuous residence requirement. And what the Immigration Service is going to look at is the reason for that requirement. So I'm going to take a quick break and let somebody much more interesting than me talk to you all for just a few minutes. So,
it's my pleasure to introduce Carl Dean. Of course, very few of us need to be introduced to him. And I've heard him introduced as the flood recovery mayor, and I've heard him introduced as the education mayor. But I'm going to introduce him to you today as the mayor that was a friend to immigrants. And it's for a lot of reasons. It started with the English-only ordinance, that he wasn't just verbally, but he was visibly involved in resisting that. And because of that, the chamber became more involved in knowing that our immigrant neighbors and how we become a welcoming community is going to affect how we're seen from an economic development point of view. And then Carl was very involved in getting Casa Azafran started on Nolensville Road, both with funding and with encouragement for people to join in with that. It was there that he was with President Obama, who came here to talk about DAPA, Deferred Action for Parental Accountability. 2 weeks ago, I think. And I think it's part of because of his leadership that created an environment in Nashville that the mayor knew this was a place, the president knew that this was a place he might come and talk about deferred action for parental accountability. But most recently, Mayor Dean opened the Office of New Americans in the mayor's office, which will be a legacy. It will continue past him being there so that our new Americans and immigrant neighbors know that they're welcome here. And Shauna Huey is also here, who's the director of the Office of New Americans. So I introduce you to the Flood Mayor, or the Education Mayor, but really the Friend to Immigrants Mayor.
Well, thank you, Kaki, for that very kind introduction, and thank you for all that you do for Nashville. This is a great organization, and I really appreciate how hard everybody works and all the work you do that is so important for our city. And I always want to say a quick word of thanks to all the attorneys who are here being trained. When we became attorneys, you take an oath, and part of your oath, I think, is to use your skills to the best of your abilities to help your country, to help your state, to help your city. And I think that's exactly what you're doing. Kaki talked about the importance of immigration to our city and what it means to Nashville. And my way of looking at things is really, I think the highest compliment anybody can pay our city, higher than the New York Times saying we're the it city, higher than making all these different lists of things, is when an immigrant decides they're going to live in Nashville. Because when you stop and think about what that means, is that somebody comes to this country, whether as a refugee or they come into the country as an immigrant, they can live anywhere they want. As Southwest Airlines would say, they're free to move about the country. And when they pick Nashville as a place to live, to put their hopes and dreams here, to put their future here, all their dreams for their children here, this is the place where they see the opportunity. This is the place where they see their chance to live the American dream. There's no bigger compliment than that. There really is no bigger compliment than that. And I think people get that. And so when they see a city that becomes more diverse and they see a city that becomes more attractive to immigrants, they not only understand that that has a huge positive economic impact on the city, it has a huge positive cultural impact on the city, but it's sort of just a sign that it's this place where you want to be and where the spirit is right. And so what you're doing helps us get that done. And we opened the Office of New Americans, and we established a number of programs to help bridge the gap between our government and our newest citizens. We started My City Academy, which is essentially a leadership training program where we're third or fourth class is about to get started, where essentially people who are new to Nashville, immigrants, can join the class and they learn about the city, how the city works. They hear from me, the council, different department heads, and others, and they become better citizens. We also launched Pathways for New Americans, which is a partnership with the federal government that we make use of our libraries and community centers to help basically be the first stop on the pathway to citizenship. There are more than 18,000 lawful permanent residents in Nashville who are eligible to become citizens but haven't become citizens yet. And I think for them and for us, it'd be a good thing if they take advantage of their right to become a citizen. And the New American Advisory Council is another group we have that essentially is made up of New Americans who advise my office on what's going on in the city and what we can do to be helpful. These programs are just part of the picture. I think this type of training helps us welcome immigrants in different ways by ensuring they have access to legal services, and that will make a material difference in the quality of their lives. So I just wanted to come by, particularly as this issue becomes more and more important to our city, and it's kind of receiving a lot of attention nationwide right now, the importance of this issue, to thank you for your involvement, thank you for doing this. And I really appreciate it. Thanks.
Thanks very much. All right. Well, thank you very much, Mr. Mayor, and let's see where we were. So those brief, casual, and innocent departures would not affect that continuous residence requirement. What the Immigration Service is going to look at in making that determination is whether the absence was short and reasonably calculated to accomplish the trip's purpose. So if you had to leave the United States for a family wedding or a funeral or something like that, and you were gone for a week or two, that would be a pretty straightforward, brief, casual, innocent absence. You also cannot have left the country as a result of an order of removal or order of deportation, and you can't have had any unlawful purpose in going outside the country or committed any unlawful act while you were outside of the U.S. And that travel cannot have happened after August 15th of 2012. Yes?
If you did take advantage of that brief, innocent departure and came back in on a new tourist visa, does that impact things in any way? That you've been unlawful, then you're lawful again, then you become unlawful?
So long as that tourist status was expired as of June 15, 2012, I don't expect that it would make a difference. We don't come across a lot of clients who've traveled since that time. For the most part, it's a risky journey. So once people are here, they tend to stay. So it doesn't come up too often, but there is that availability for a short absence not to have broken that residence requirement. You have to meet certain education or military service requirements. So there are a couple of ways that you can meet that. If you are enrolled in a public or private elementary, middle, or high school, if you've graduated high school, received your GED, or if you're in an educational program like a GED program, or a program intended to aid in literacy, education, lead to post-secondary education, job training, or employment. So that category is kind of a broad, less defined category that, again, doesn't come up as often. Or if you've been honorably discharged from the U.S. Coast Guard or Armed Forces. I have never had a client who qualified for DACA based on military service, and an undocumented person in general would not be eligible to enroll in the military or enlist in the military, but occasionally somebody sneaks by the recruiter, and so it is possible that if a person has an honorable discharge from the armed forces, they could qualify based on that. An example of that education, literacy, or career training program, there are some programs here in Nashville that are intended to provide immigrants with it's not a traditional elementary, middle, or high school education, but it would allow someone who hasn't completed that level of education in their home country to continue here. There's a program, for instance, through the Mexican consulate that provides those services. So there may, I think the first person that I've seen who's sort of enrolled in one of those programs has come through our office recently. For the most part, the people that you would be working with are either in high school, have graduated high school, have a GED, or are working toward a GED. That's by far the most common way that people are meeting the education or military service requirement. Now, if a person is in a GED or other educational program, the Immigration Service wants to see that it is a program of demonstrated effectiveness, and the burden of proving that is on the applicant. So if it's a federally or state-funded program, that's pretty easy. You would want to show where the program gets their money. If it's from the government, then they feel pretty certain that it is an effective one. If they don't receive government funding, then the Immigration Service would want to see that the program has been around for a while, that it is actually helping people achieve the goals that it says it's going to. Basically, they don't want you to just be sitting in someone's living room saying you're preparing for the GED. They want to see that this is a real program that's established itself in the community. So if someone is in a GED or education program, they may need to include a little bit of additional documentation to show that the program that it really exists. Certain criminal issues can make a person ineligible for the DACA program. So any felony conviction would mean that you are not eligible to apply under the DACA requirements. A felony, as far as immigration is concerned, is any federal, state, or local criminal offense punishable by imprisonment for a term exceeding a year. So regardless of the sentence imposed, if it's punishable by a year or more in prison, that would be considered a felony, and it would mean that you could not apply for DACA. State felonies that are actually immigration offenses, so if your state has created a law that makes it a crime to be present without documentation, that would not disqualify the applicant if it's a state law immigration crime.
How does expungement and things like that factor into that?
So in a lot of areas of immigration law, whether or not the crime is expunged doesn't matter. For DACA purposes, if you have an expunged conviction or an expunged criminal charge, it will still be considered, but it wouldn't make you automatically ineligible. So if it was a felony conviction that had been expunged, I don't know how likely that is, but say that happened, it wouldn't mean you couldn't apply, but the officer does make a case-by-case determination about each applicant, and they would consider that in their determination.
Is that true about just juvenile offenses?
So juvenile offenses, again, a juvenile offense that would, let's say, if it were an adult crime, it would fall under one of these significant misdemeanor categories, but it was a juvenile offense. It won't make you automatically ineligible, but it will be considered. Okay, so a felony conviction would mean you shouldn't apply for DACA. A significant misdemeanor conviction would also make you ineligible under the DACA program. This would be any criminal conviction that is a misdemeanor, so an authorized sentence between 5 days and 1 year. And then there are two ways that you can meet this significant misdemeanor definition. One is based on the category of crime. So if it's a crime of domestic violence, sexual abuse or exploitation, burglary, unlawful possession or use of a firearm, drug trafficking or distribution, or DUI, regardless of the sentence imposed, that would be considered a significant misdemeanor. The other way that you can fall into that significant misdemeanor category is if you have a sentence of a time in custody of at least 90 days for that crime. Again, unlike in a lot of areas of the immigration law, a suspended sentence isn't going to count toward that 90 days, nor is additional time that you spend detained pursuant to an immigration detainer. So they want to look at a 90-day served sentence. And if you have that, that would be considered a significant misdemeanor, and you would not be a very good DACA candidate. Yes?
Sorry. I'm just looking at, these 3 bullet points, and every criminal offense in Tennessee has an authorized sentence of 5 days or more. So if someone has any misdemeanor offense that they have a conviction of, are we just looking at the lower 2 bullet points?
So the question is yeah, okay. I understand what you're saying. This could be set up a little differently. So the question is whether any of these 3 bullet points is the significant misdemeanor. So sorry, the second 2 probably should be under the first one. So the first one is our threshold to say, yes, this is a misdemeanor. There's a sentence of between 5 days and a year possible. Then if it falls into one of those other 2 categories also, it would be considered a significant misdemeanor. So here we've got our non-significant misdemeanors. So anything that doesn't fall into one of those categories but is still a misdemeanor would be considered a non-significant misdemeanor. If you have 3 or more convictions for a non-significant misdemeanor that don't arise out of the same event or on the same date, you would not be eligible for DACA. So if you have, so we're looking, at three separate occasions when you've been convicted of a misdemeanor. A minor traffic offense, such as driving without a license, which is punished as a misdemeanor in Tennessee, would not be considered a non-significant misdemeanor, however. So you will very likely, I don't know if most, but many of the clients that we work with in the DACA program have a driver's license charge in their record, but that's not going to count toward these 3 or more non-significant misdemeanors for purposes of determining DACA eligibility.
How common is it to run into the issue of people not having paid tickets, and therefore having to serve time because they've got unpaid tickets? Is that a big issue?
Not too often, I don't think. For the most part, people have gone to court date and paid whatever fine was required of them. We don't have a ton of people with outstanding tickets or outstanding warrants or anything as a result of traffic issues that have come up. If somebody did have something like that, I would recommend that they get everything straight before applying, because they may, even if it is originally a traffic issue, if it becomes something more serious or is outstanding, hasn't been resolved yet, then there may be questions from the Immigration Service about it. So as we saw earlier, immigration-related offenses under state law would not be treated as disqualifying felonies or misdemeanors. Expunged convictions in juvenile adjudications would not automatically disqualify the person, even if they do fall under one of those categories that normally would. If a person is under 18 but tried and convicted as an adult, that would be considered an adult conviction rather than a juvenile adjudication. And the entire criminal history, including those any expunged charges, including the juvenile record, will be considered when the officer's making a determination of whether the person warrants the exercise of prosecutorial discretion. So every case is adjudicated on a case-by-case basis to decide whether the person deserves to have this protection. And they will consider even a criminal history that doesn't make the person ineligible in making that decision. If the applicant is a threat to the national security or public safety, they would not be eligible for DACA. The main context in which I think this is likely to come up would be somebody who was a member of a gang. And there's a specific question on the form that says, have you ever been affiliated or involved in a gang? If someone can't answer no to that question, then they probably are not a great applicant for DACA. Certainly for an affirmative DACA application, if they were already in immigration proceedings and facing deportation, that might be a different question. But as far as affirmatively applying, if they fall into any of these categories of a threat to the national security or public safety, it probably wouldn't be a great idea for them to apply. The Immigration Service has said that in exceptional circumstances, a person who meets those that level of a threat to national security might be granted deferred action, but they don't give us a very good sense of what those circumstances might be or how very exceptional they would have to be. So again, that's something to look for if the person potentially has any of those issues. Okay. So this first bullet point applies to the current DACA program. Again, the DACA expansion will remove that upper age limit, but for anybody who's applying today, they have to have been under the age of 31 as of June 15th, 2012. And they do have to be at least 15 years old at the time of application. The exception to that rule is if a person is in removal or deportation proceedings or under a final order of removal, they can apply before the age of 15. If they were in proceedings previously, but those proceedings were terminated by an immigration judge, which might have happened because the judge recognized that they're eligible to apply for DACA, then they'll have to wait till they're 15, just like anybody else. So when we talked at the very beginning about people aging into the program, these are who we're seeing. A pretty good number every year of people who are turning 15 and become eligible to apply. Let's see. Where are my true or false questions? So just to make sure you've been paying attention, I know you have the answer, so pretend like you don't. True or false, a person enrolled in a GED program may be eligible for DACA? True. Okay. A person under the age of 15 cannot apply for DACA. True or false? False, except in those, there are certain circumstances where that is possible. Okay, so that is, those are the eligibility requirements for the Deferred Action Program. Now, we want to talk just a little bit about how we're going to prove that the applicant meets those requirements. So we want to be sure that we're thoroughly documenting every eligibility requirement, because if the immigration officer gets the packet for the applicant in front of them and they don't think that the person has established each of those eligibility requirements, they're going to send what's called a request for evidence. And that request for evidence is going to be a very specific list of what the immigration officer wants to see in order to make a decision about the application. It's also going to have a due date on it. Generally, they give you 3 months to submit the information that they're looking for. But if they don't get what they want, or they don't receive it in time, then they can, and very likely will, deny the application. So it's best if we can do this all in one step, get everything documented up front. Again, you do have that second opportunity, and the good thing about the RFE is it is a really specific list. They don't just say, hey, we don't have enough stuff, send us more. They say, we want to see additional evidence that you were present in 2013 or present on June 15th, 2012. So they do tell you what they're looking for so that you can really concentrate on finding and submitting evidence to meet those requirements. But it's even better if we don't even have to deal with that in the first place. As you're submitting documentation, you just want to submit legible copies to the Immigration Service. If you send them originals, they'll hang on to those. So an ordinary photocopy is what they're looking for. All right, so first we've got to establish who this person is, and there are a couple of ways we can do that. If the applicant has a valid passport, then a copy of that biographical page is sufficient to establish their identity. It shows their name, their birth date, and their country of citizenship. So that kind of gets us several of the eligibility requirements in one go. So that's a very good document to have. If they don't have a passport, then we would want to submit a birth certificate and a form of photo ID. That's slightly more difficult only because the birth certificate requires an English translation. There are, I know, organizations that will do that, and I think we're hoping as part of the workshops to be able to offer that service as well for people who are coming in to apply in the workshop setting. But a birth certificate along with a photo ID would also establish the person's identity. That photo ID could be any number of things. A school ID works. If they have an expired driver's license. So for a while, Tennessee did issue driver's licenses to Tennessee residents who didn't have a social security number. So some people still have those from like the mid-2000s, I think it was. They may have an expired license. Another government ID from their country of citizenship could serve as that photo ID, or a military ID or other U.S. government issued ID. So anything with a photo. I've heard from other people who have had mixed results. Some schools don't issue an ID card, but the school would give the student a letter that says, here's the student's photo, here's the student's name, this is who this person is. He's a student at our school, and I've heard kind of mixed results with that. So if the school doesn't have an ID card that they issue, then we may want to consider what our other options are for that photo ID.
But it has to be government issued or school issued. It couldn't be like their ID from the YMCA or something.
Yeah, a government issued or school issued ID is what we're looking for. I haven't tried with a Sam's Club card or anything like that, but the examples the Immigration Service gives are all issued by the government or the school. Okay. So then the applicants got to prove when they came into the United States. We need to show under the current program that they entered before the age of 16 and before June 15th of 2007. Under the expanded program, it will be before January 1st, 2010. If they entered with a lawful immigration status, then a very, very good proof of their entry will be whatever entry document they received when they were coming into the United States. That may be a stamp in their passport. It may be a visa that was in the passport. They may have received an I-94 card, which is an entry document that Customs and Border Protection issues for some entrance to the United States, not all, or other evidence of their entry into the U.S. Ideally, that document would also say when that status expired. So for instance, if they came in with a tourist visa, and again, that's I think the only lawful status that we have seen with these DACA applicants are people who entered with a tourist visa. I haven't seen anybody with a different type of status, although it's possible. So ideally that stamp would also say when that status expired, so that you have an easy time showing that their lawful status expired as of June 15, 2012. Other immigration documents that may have an entry date would include a notice to appear. So that's the charging document. When a person is placed in removal proceedings, it generally will allege that they entered the United States on or about a certain date. If the government believed it then, that's pretty good evidence that they should take our word for it now. So if the person has been placed in removal proceedings, that notice to appear will generally have an entry date on it. If the applicant has never encountered immigration, either by entering lawfully with some sort of a visa or by being placed in removal proceedings, then what we want to do is show that they were in the United States as of their 16th birthday and as of June 15, 2007. So we want to show that they were living here before that time. And we can do this with a number of different records. That could be, this is not an exhaustive list either. School records can be really valuable because a lot of times, especially if a person comes in under the age of 16, I mean, especially as a very young child, one of the earliest things their parents are going to do is enroll them in school. So very, very often if a child came in, particularly when they were very young, you'll have school records from really close to the time that they entered that you can use to show the proof of entry date. If they have a plane ticket or a bus ticket that shows when they came into the United States, they could use that. Vaccination records, again, in order to enroll in school, you have to demonstrate that your vaccines are up to date. So that's often one of the earliest things that a parent will do for the child is take them to have vaccines done. With those vaccine records, you have to be careful because a lot of times the clinic that they go to will transfer the vaccine records from the country of citizenship to the new record. And if it doesn't indicate where the vaccine was provided, then the value of that can be a little bit limited. So they may have vaccines listed on their record from way before they came into the United States. And if it doesn't distinguish between those, then it may not be as useful for some of our purposes here. Medical records, if they went to see a doctor for any reason, or baptismal records, those kind of things. If it was an older person, if they were working, employment records could be used. If they sent money out of the country and have a receipt from that, that's another indication they were here. Bank statements, vehicle registration, tax records, mortgage or lease information. So any document with the person's name, a date, and an indication that they were in the United States could help you prove that entry date. All right, then we want to see the proof of immigration status, that they didn't have a lawful immigration status as of June 15th, 2012. So on their passport stamp or I-94 document or other entry document, they should have a stamp that indicates what their status was when they entered and how long that status lasted. Again, with a tourist visa, it's generally 6 months. If it was some other form of status, it may be longer, or it may say duration of status. If it was one of those, like a student visa that says duration of status, we might have an extra step or two to make sure that the person actually didn't have a lawful immigration status as of June 15th, 2012. If they've ever been in removal proceedings, then that charging document could be used to show that they didn't have a lawful immigration status as of that time. Again, in addition to alleging when they entered, it'll allege what their immigration status was at the time that the NTA is issued. So it may say, you are a citizen of Mexico, you entered the United States on June 1st, 2007, you did not have a lawful immigration status at that time. Or you had a tourist visa as of this date, but it had expired and you didn't have a lawful immigration status. So if they've been in removal proceedings, then that notice to appear may have information that's helpful for this requirement as well. If the applicant didn't enter with a lawful status, if they came into the United States with no visa, you don't have to prove that that their status had expired as of June 15, 2012, because they would have entered without any lawful status originally. So in proving continuous residence, The Immigration Service has said they want to see at least one document for every year that we have to prove continuous residence. So that would be at least one document from 2007 through 2014. I try to shoot for at least one document per quarter, just to be a little bit more thorough in documenting that the person has continuously resided. Because if there is a gap of more than a few months, a lot of times you will get an RFE asking for additional proof of the person's residence. And we'll look in just a second about some ways that we can help fill in those gaps, but if we don't have any, that's even better. Here are just a few examples of ways that we can prove continuous residence. Again, just like with the proof of entry, a document that's got the person's name, a date, and an indication that they were in the United States is what we're looking for. School records can be really valuable for someone that was in school for a lot of that time because they'll cover pretty much the whole year. I have never had an issue where we submitted school records and the officer said, well, what about the summer? That hasn't come up yet for me. So if you can cover the school year, that tends to be enough of that year that they seem to be satisfied with that as proof of continuous residence. Medical records can be really valuable, especially if someone has had to see a doctor a lot. We've sometimes used medical records for a child in order to prove that the parent was here. If they say, you know, medical history given by mom or something like that, then we can kind of indirectly show that, or I mean, it's fairly direct, but even if it's not the mother's medical record, it may have an indication that she was in the United States at that point. So that's a good one to use sometimes if somebody doesn't have some of these other documents. Utility bills can be really useful. If the person doesn't have the physical bills anymore, they can often get a billing history from the utility company that shows all the dates that they paid. Mm-hmm.
So when we talk about bills, you know, like they're in the name of one person a lot of times.
Mm-hmm.
Okay, so is that a problem, or can you draw that line between people with marriage certificates and then?
Mm-hmm. I have not tried to do it that way. The question is whether if the utility bill's in the wife's name, for instance, could we use that as evidence that her husband was also living in the country at that time? I haven't had to use them in that way. If you were going to try, I would at least want to probably try to include a lease that had both people listed as occupants.
Just do the best you can.
You do the best, yeah, you do the best you can. We haven't had anybody that suggested that was the best that they could do. Usually, we can come up with at least something that gives us a little bit more for the individual.
Do these people ever have charge cards and things like that show evidence of spending?
Bank statements are fairly common. I don't know if I've gotten a credit card statement from anybody.
ATM withdrawals.
Mhm.
Okay, so you can use all that.
Mhm.
Okay.
Let's see. Here are some other examples. If the monthly things are really helpful, I think I've got utility bills on there twice because they're so helpful sometimes. But if you can, like if you can get a billing history from a utility company or from a apartment manager or something like that, even if the person doesn't physically have those documents anymore, you may be able to get proof that they were making those payments periodically. Or a car payment. We've had some people who brought in records from a car dealership to show that they were making payments periodically on the vehicle. I've had one lady bring me a printout from her gym that said when she visited the gym. So if somebody's got a periodic or a membership to a gym, a library, a Sam's that could show when they visited, that could be useful. So if there are some gaps in the documentation, you can use affidavits in a limited way to help fill those in. So a lot of people will ask if they can use the affidavit in particular to prove that they were here on June 15th, 2012, and the answer is no. Affidavits are useful in order to fill in gaps in continuous residence, or if the person did have one of those brief, casual, and innocent absences, they can be useful to help show the circumstance of that absence. So if a family member could say, yes, she was gone from the United States for 2 weeks, but it was because her grandfather was sick in the hospital or something like that. So an affidavit can be useful in that circumstance, or if the person has, a 6-month gap in their residence, then a neighbor could say, well, you know, he was living next door to me during that time. I saw him every morning walking his dog. You know, how kind of as specific as they can be about how they would know that the person was living in the United States during that time. You would want at least 2 affidavits from 2 different people who could write that sworn statement that the applicant was present in the United States during that gap in the documentation. All right, so this is the piece that's hardest for a lot of people. We have to show that the applicant was present in the United States on June 15th, 2012, which was a Friday during the summer. So nobody was in school. We have had really good luck with giving, for people who were enrolled in school around this time, for including a copy of their school attendance records and then a copy of the school calendar that would show, okay, they would have been in school up till May 24th and they started again on August 1st. We've actually had a lot of luck with that. So that kind of narrows the gap sufficiently for a lot of the immigration officers who are looking at this. Basically, we want to get as close to June 15th as we possibly can. A lot of the same documents that we use to prove continuous residence are helpful here. So if you've got somebody who did have a bill in their name, then a lot of times there'll be a payment or 2 close enough to this date that that'll give us the proof that we need. The harder cases are where people had already graduated from high school or weren't attending school, but maybe were living at home with parents so they didn't have any bills in their name, or living, you know, their spouse was paying the bill. So there are cases like that, and this is where we really have difficulty in documenting this requirement for people in that situation. For a while, we were having pretty good luck submitting Facebook posts from around that date, because the post will say, you know, posted near Nashville, or, you know, it'll have a location tag on it. Those have started coming back with an RFE to say that since Facebook can be edited from anywhere in the world, it's not good enough. What they can be useful for is, or one example of a way that we've used it is, we had a young woman whose brother was in the hospital, and she posted on Facebook something about, you know, being in the waiting room with her mom for her brother to come out of surgery, and then we had a copy of the brother's medical record that shows he was at Vanderbilt Hospital on that day. So it can be kind of used in a circumstantial way with some other corroborating evidence. That was successful for us. So it may still be useful in some cases. For the most part, they seem to have discounted that pretty substantially. By this point, I guess they got a lot of them and decided it wasn't the best proof. But they can be helpful if you have some additional context to give there. Let's see. Okay, and then our proof of education or military status for somebody who's graduated from high school or has a GED already. That's pretty easy. You just want a copy of their diploma or a copy of the high school equivalency diploma. Again, I haven't ever had a client that was qualifying based on military service, but discharge records, personnel records, or health records from the military could be used. If the person's in school, that's where you may have to do a little bit more work. If they're enrolled in an elementary, middle, or high school, you want to have as up-to-date of a record as you can. So if they're, you know, ready to submit the application tomorrow, and the proof that they have that they were enrolled in school is their report card from November, it would be a good idea to update that. A lot of times, the school counselor or registrar can print out a copy of the student's attendance all the way up till the date that they are asking for it. So that's very good. They could ask that registrar, that school counselor, to write a letter for them that says, this person is a student in our school. They're currently enrolled for the 2014-2015 school year. So that's very helpful. But you want to make sure that it's very recent if it's based on current school attendance. Yeah. Just a letter is fine. And that's one of the exceptions to that rule that we don't generally submit originals. If they're bringing in something that was created specifically for the application, like a letter from the school counselor, we do want to submit that original, or an affidavit, of course, we want to submit those originals. But just a letter from the whoever is the attendance secretary or whoever would be the appropriate person can be really helpful for that. But it should be as close to the date that they're submitting the application as possible. That was kind of came up several times when people were applying during the summer. They had, something from the last school year, but the new one hadn't started yet, and so when they submitted that, it was a month or two old, and they might get an RFE asking for updated school records in those situations. And then just like we talked about before, if they are enrolled in a GED program or other educational program, they need to show, the requester, the applicant needs to show that that program is one of demonstrated effectiveness, whether it's funded by government grants, or if not, the record of success, how long it's been around, those kind of things. Okay, if the person has a criminal record, they're going to need to document that. So if they've been arrested and charged as an adult, they would need any arrest record relating to that and any court disposition relating to that charge. If the charge has been expunged, it's wonderful if they have the expungement order, because then you can include that and show that that charge has been expunged. If they no longer have that, you generally can't get it. So what they would have to do is explain that they had been charged with X, Y, or Z, but that charge has been expunged. On the form, and Bethany's going to go over the forms in a lot of detail in just a few minutes, on the form it does ask if you've ever been subject to a juvenile adjudication. So if a person has a juvenile record, they would need to disclose that. However, the actual documentation of that record is protected from disclosure under Tennessee law. And the Immigration Service recognizes that that's true in a lot of states. So they don't require you to submit the actual adjudication from the juvenile court.
So, I mean, I'm not in the criminal space, but I mean, that's, you're kind of assuming a person stayed in Tennessee their whole time in the United States. I mean, I'm thinking some people have probably moved from state to state. They might have had their juvenile record in one state and now be living in Tennessee, taking advantage of this program. Do we have to reach back to that state where they were before, or is it all going to be Tennessee law that governs? I just don't know anything about that.
That's a very good question. I would expect it would.
I think it's the law of the state where the juvenile record is. So if they lived in Texas and those records aren't protected, in Tennessee they're protected from disclosure except for the court order, and that usually satisfies immigration. But if they moved from Texas and had a juvenile adjudication there and those records aren't protected, I think that you would have to get copies of those and attach them.
And forms exclude minor traffic offenses?
So when the question of whether you've ever been arrested, cited, detained, charged, convicted says do not include minor traffic violations such as driving without a license, do include juvenile adjudications or expunged charges. So it's very explicit directly on the form what they want you to include and what you're able to exclude. Okay. This is not going to apply in a lot of cases, but if the person has been in removal proceedings and has any court orders or other documentation issued by an immigration court, they would need to include a copy of that. There is a question on the first page of the form that asks, have you ever been subject to removal proceedings, ever been ordered deported or removed? And if the answer to any of those questions is yes, then they would want to include paperwork that shows what happened in that court proceeding. Okay, another true or false question. True or false, an applicant can use an affidavit to prove that he was present in the United States on June 15th, 2012. That is false. Very good. We are about to move on and talk for a little while about the kind of the nuts and bolts of applying for DACA, but before we do that, does anybody have any questions about the eligibility requirements, how to document them, anything at all? It won't be your last chance to ask those. So. All right, to Bethany Jackson, I mentioned earlier, is our DACA attorney and kind of heading up our efforts for the year. And she is going to walk you through the forms and sounds good.
So while we're switching microphones real quick, in the right side of your package materials, there's a set of documents called Training Example.
If you guys want to grab those and just read through, this is a completely made-up case that we're just going to walk through to sort of understand how you actually do the forms. Gotta find the right kind of shirt. All right. Did everybody find the training materials? Yep. All right. So first of all, I want to say thank you to everyone for being here. We really appreciate it. As Mayor Jean put it so well, there's a huge need in Tennessee for legal services for DACA applicants. Adrienne might have mentioned in her introduction, when DACA was first announced in June of 2012, the estimate was that there were 25,000 potentially eligible people in the state of Tennessee. And of that number, only 6,000 to 7,000 have actually applied successfully for DACA. Some of that 25,000 are people that are aging in, as Adrienne mentioned, but we think there are probably a lot of people out there who just haven't applied because of lack of information or understanding. Some people have been told not to apply because of this risk of turning information over to immigration services, but there are a lot of people out there that could benefit from legal services. So thank you very much for being here. And I should back up a step and say I've been the DACA attorney at Jfon since December 1st of last year, so just about 2 months. Adrienne, we doubled our legal staff when I joined. Adrienne has been the sole attorney at Tennessee Justice for Our Neighbors, which is one of the only places in the Metro Nashville area that provides free or low-cost legal immigration services. So we're gearing up for a lot more capacity. So I'm going to talk about what you do to actually apply for DACA. And there are 3 immigration forms that you're going to file with every DACA application. The first one is the I-821D, called the Consideration of Deferred Action for Childhood Arrivals. The second, and that's a 7-page form. The second form is application for employment authorization. And then attached to that is a third form called an I-765 worksheet. The Customs and Immigration website actually has great information. They have a set of instructions for each of these forms that answer specific questions about the form. And then they also have the frequently asked questions, which is a fantastic resource if, as you're going through the form, a question comes up and you're not sure, for example, about whether a crime is a significant misdemeanor or not. There's great guidance there. So as I said, we have some training materials for Jose Luis Galvan Martinez. And if you guys can turn to the I-821D, it's actually the 4th page in the training materials. So this is the form that you'll use to actually request deferred action. And it's fairly straightforward. There are great instructions sort of at each step of the way. You'll see that part 1, you need to indicate whether it's an initial request or a renewal request. That's because, as Adrienne mentioned, when DACA was first announced, the grant of deferred action was for 2 years. The first DACA grants were given in the summer of 2012. So we have a lot of people who, in the summer of 2014, became eligible to renew. So we're using the same form for first-time applicants and renewal applicants, and you just need to indicate in part 1 whether it's an initial request or a renewal request. We're going to go through the forms as if this is an initial request first, and then I'm going to go back and tell you the changes you need to make for a renewal request. Full legal name is the name on the applicant's passport. Address is fairly self-explanatory. Question 5 is important. Are you now or have you ever been in removal proceedings? And there's a period of time when immigration referred to removal as deportation. That's just a change of terminology. It's the same thing. So the applicant should know the answer to that question. They've typically gotten a notice to appear and had to appear in court. In this part of the world, it would be in Memphis. That's where the immigration court for this area is. Page 2 asks for an alien registration number. That's a number issued by the Immigration Service, and most people applying for DACA for the first time will not have a number unless they've been in some sort of removal or deportation proceeding. Same thing, they typically won't have a social security number. A question that comes up a lot is sometimes people have worked under a social security number issued to someone else
you don't use that in this form. Immigration only wants a social security number issued to the person who's actually applying. Questions 9 through 9 to 10 is information that you can take from the passport. City, town of birth, country of birth. 11 is always going to be that they're residing in the U.S., then country of nationality. Question 14, the other names used. A lot of, like the person in our example, Jose Luis Galvan Martinez are both his surnames. But in this example, his checks are issued to Jose Luis Galvan. And you see that a lot in school records. A lot of our Latino clients will use the first surname only in their school records. So that's a good place to put any variation of their name that's going to appear in a record that you're submitting with the application. Obviously, if they used an alias, you should put that there too. I actually haven't run across a client who's done that, but you never know. The next set of questions, ethnicity, race, height, weight, eye color, hair color. This is really up to the applicant to describe how he or she identifies. At the back of this training packet, there's a frequently asked questions, and immigration hasn't given any guidance about the race categories in the DACA context, but they have in the citizenship context. What you get a lot of the time when you ask people to choose one of those races is sort of a blank look, because most of us are a mix of those 5 categories. But as I said in the frequently asked questions, there's an explanation of what immigration's guidance in the citizenship context. All right, part 2. This is one of the most important questions, as you know, because in order to qualify DACA, the applicant has to be able to answer yes to this question. Okay, so if they can't say that they've been continuously residing in the U.S. since June 15th, 2007, your next question is, when did you leave and for how long you were gone? And that's when you can have the conversation about the brief, casual, innocent departure. Okay? But if they came in 2006, they left in 2008, went to school for 2 years, and then came back in 2010, they're not going to be eligible for DACA. Next page is addresses. So for first-time applicants for DACA, immigration wants to know every address they've lived at since they came to the U.S. And this is complicated for a lot of people because people move frequently. So my recommendation for this piece is you have them sit down and make the list separately, and then you're going to start with their current address and work in reverse order. And a lot of people will need more than the 4 spaces, so if you flip to page 7 of the form, you'll see space to add additional information. And you just need to make sure on page 7 in question 1 you write in the name, a number if they have one, and then reference the page part and item number that you're adding additional information for. All right, the next, going back to page 3, the next part is travel information. This section is actually a little counterintuitive. If you go down to question 8 and you say, have you left the U.S. without advance parole on or after August 15, 2012? I would say in 90% of the cases that I've worked on, people say, oh, I haven't left since I came in. I would say the vast majority of people applying for DACA came across the border once, often without speaking with anybody in immigration. You will have some clients that came in on some sort of visitor visa, but the vast majority just walked across the border and they never left. So I usually start with question 8 and then I say, have you ever left since? If they say I've never left since coming in, that's your answer. If they say that they left after they came, but not since August 15th, 2012, you need to fill in that information on questions 6 and 7. Again, question 8, if they say, yes, they've left the U.S. without advance parole, that's immigration speak for permission from immigration to leave. If they've left on or after August 15th since 2012 without advance parole, they're not eligible for DACA. Okay, so that's another sort of red flag. Question 9, information again from the passport. It doesn't matter, on 9C they ask for the passport expiration date. You'll see in my example, I have an expired passport. It doesn't matter for purposes of DACA that their passport isn't current. Part 3, again, question 1 is a very important question. They have to be able to say, yes, I initially arrived and established residence in the U.S. prior to 16 years of age. Because remember, that's one of the requirements. You have to have arrived before 16. Date of initial entry. Some people know exactly what date they came in. Some people know the month and the year. Some people only know the year. But we try to get people to be as precise as they can be without inventing. Same thing for place of initial entry. Some people know, this refers to the U.S. side of the border. Some people know exactly where they came in on the U.S. side. Some people know the state. So if they only know Arizona, California, Texas, that's fine too. So any questions so far? Nope. All right. Page 4, part 4. If you do this document on paper, you can write in one of those choices: no lawful status, status expired, parole expired. If you do it online, on the immigration website, you can download PDFs for these forms, and they're fillable. It's an easy way to do it. You just select one of those. No lawful status means that they didn't come into the U.S. with any type of visa. They just, in my example, walked across the border. If they came in with a visitor visa, but the visa is expired, then you'll choose status expired. Same thing for parole. If at some point they were paroled into the U.S., which is another immigration concept, you put parole expired. If they had lawful status, if they don't fit one of those categories and had some kind of lawful status on June 15th, 2012, true or false? They're eligible. False. Okay, so another red flag. 5A is the question about were you ever issued an arrival departure record. That's the I-94. It's a card that will appear in their passport usually, and it will have a number. If they were issued a 94, you check yes and then put the number in 5B. And then also 5C, the expiration of the I-94. Education information, this is designed to address the education requirement. So you just indicate if the applicant's in school or is a high school graduate or is in a GED course. The 7 is the name, city, and state of the school currently attending or where they graduated. And then question 8 is either the date of graduation, or if they're still in school, you actually put the last day they attended classes. So if you're seeing somebody on a Friday and they were in school that day, that's the day you put. Military service information, I think Adrian mentioned that as a person without lawful status, you're technically not eligible to serve in the military, but it happens sometime. I wouldn't anticipate getting too many people that say yes to that, but if you do, fill out that information. Okay, part 4, number 1, this is the question that sometimes brings the most problems. The question is phrased, have you ever been arrested for, charged with, or convicted of a felony or misdemeanor, including incidents handled in juvenile court in the U.S., but do not include minor traffic violations unless they were alcohol or drug related? So I think somebody over here was asking earlier about expunged convictions. If you have an expunged conviction, you have to answer yes and then explain on page 7, the place for additional information. So, and just take note that the question is arrested for, charged with, or convicted of a felony or a misdemeanor. And I think my default, and I don't know if Adrian's on the same page, is that if everybody that applies for DACA is going to go for fingerprints and there's going to be a criminal background check. If in doubt, disclose it, because you don't want the person to apply and then something comes back on the criminal background check and immigration thinks that they weren't forthright in the application. So any questions about that, about the criminal record piece? All right. And if I have an applicant who had some sort of juvenile adjudication, on page 7 I have the applicant explain in his or her own words what happened. I was skipping school, I was, spray painting an apartment building, I saw a judge, he made me write an apology, and then I was given pretrial diversion. Just something in the applicant's own words. And then I add something that says juvenile court records are protected from disclosure absent court order in Tennessee. All right, then question 2 addresses arrests, charges, or convictions of crimes in countries other than the U.S. It's unlikely you'll have anybody that answers yes to that. Most of these people, since they came in before they were 16 years old, they're not likely to have been arrested or charged with anything in the country they came from, but obviously ask the question. 3 through 7 are questions that address sort of immigration's priority for deportation, things like terrorism, gang membership, torture, genocide, human trafficking, killing, causing severe injury, recruiting people under 15 to serve in the military or in combat. And I've never had anyone answer yes to any of those questions. So if you have somebody answer yes, I'm particularly interested in questions 6 and 7. I'd love to hear from you. Okay, so page 5. Most of the people that you will work with for DACA will be able to check I can read and understand English because of the education requirement. They will have attended high school or are attending high school here, and so can check the 1A. If for some reason that's not the case and you used an interpreter 1B, then below that the applicant is going to sign and certify that everything's accurate and complete, provide telephone numbers, email address. Part 6 is for the interpreter information. If you use one, you leave it blank if you didn't. And then Part 7, page 6 is the information for the preparer. And when I represent individual clients through Jfon, this is my information. In our workshop setting that we're doing as a collaboration with Camila, who you met at the beginning from Tennessee Immigrant and Refugee Rights Coalition, there the volunteer filling out the form puts his or her name down, and then Turk is the organization on that. So that's what you see on this page. We talked about page 7. So any questions on that first form, the I-821D? Nope. All right. The next form is actually right after the first page. This is the application for employment authorization. And in immigration speak, application for employment authorization, the EAD, is the work permit. So show you guys what that looks like. This is what the DACA recipients will get. It's a card that looks like a driver's license. And it has, once they're approved for DACA, it has the A number on there. I don't know if you see where it says USCIS number, and then there's a 9-digit number. That's going to be their A number when their work permit arrives. And then it has the date that it's valid from and the date of expiration. All right, so if you go back to the I-765, this is a one-page form for the work permit, also known as the EAD. And the box at the top is for immigration, and you'll start where it says, I am applying for. You have 3 choices. If it's a first-time applicant, they'll almost always be asking for permission to accept employment for the first time. Sometimes people have had a work permit for some other reason, so just double-check and make sure that they've never had a work permit from immigration before. Then question 1 is family name. Immigration wants that in all caps. You'll see we wrote Galvan Martinez in all caps. U.S. mailing address, then you have some information again from the applicant's passport, country of nationality, place of birth, date of birth. It asks again for Social Security and A number. First-time applicants likely won't have those, so you put not applicable or leave it blank. Question 11, you indicate whether they've applied before. If they have applied before, the top of the next column, you're going to indicate which USCIS office processed the application. And in the frequently asked questions, there's a little guide. You'll see on the work permit I had up a minute ago, I think it says SRC, and that is in fact Texas. They're not obvious. Vermont Service Center issues most of the work permits for DACA applicants, and their initials are EAC. Yeah, it's SRC on the example, and I think that is Texas. But I have a cheat sheet for you on the frequently asked questions. Yes, that's the Texas Service Center. So which USCIS office will come from the old work permit? The date that it was issued is the valid from date on the work permit. Then you're going to 12 and 13, date and place of last entry in the U.S. Just make sure that matches whatever you put on the I-821D, that you're providing the same information. 14 is the same question again, status at last entry, B2 visitor, F1 student. Vast majority of people you're working with are probably going to be no lawful status because they just walked across the border. And current immigration status for first-time applicants will be no lawful status. Question 16, who may file Form I-65? In the instructions on the immigration website for this form, there's a series of codes that you refer to, but for DACA, it's always going to be C-33. So anytime you help somebody apply first time for DACA or renewal, that code's always going to be C-33. Question 17 is not applicable to DACA. And then there's, again, a certification for the applicant to certify that the information is complete and correct. And they're going to sign and date. And then below the signature of the person preparing the form, that's going to be you. Or in the workshop setting, it will be the community volunteer that fills it out. And you're checking for that. So any questions about the work permit application?
I guess I'm still a little confused about who the preparer is, because like we do, I mean,
Yeah.
other type of visas, you some dispute about that, sometimes if you do pro bono.
Sure. And that actually is a great question. So if you're an attorney representing a client outside of a workshop setting, you have to file a notice of appearance. And I'm going to show you guys that form, or actually have the form in your materials. It's the G28. And that is what says to immigration, I'm the attorney representing the client in this case. Because immigration recognizes that there's so many people that need to apply for DACA and there's a need for pro bono legal services, they've actually given a guidance that says in a workshop setting, you're not required to file a G28. So the way our workshops are set up, it's a collaboration between Jfon and Turk and Conexión Américas, is Turk pre-screens all the applicants, so everybody should show up at the workshop eligible to apply. Then a non-lawyer volunteer sits with the applicants and actually fills out the form. And then the attorney piece of it is to make sure that it's filled out correctly and to go over the risk and responsibilities of applying for DACA. And just to make sure that the applicant understands what he or she is applying for, what the possible risks are, and you know, what the benefits are. There's a lot of
What kind of model rules? I mean, is that gonna work with the model rules?
yeah. There's a lot of misinformation out there. A lot of people think that if you have DACA for a certain number of years, then you can apply for a green card or residence, or you know, you can become a citizen somehow. So the attorney piece is very important in sort of explaining what exactly it is, and you know, checking to make sure that the forms are done correctly. So in the workshop setting, the preparer will be the non-attorney volunteer that actually physically wrote out the form.
And they understand we don't represent them then, is that?
We have that conversation. We have that conversation with them very specifically. And we've also put together a sheet of information for them to take with them, explaining the risk and responsibilities and addressing specifically, you know, you've had a conversation with the attorney in this workshop, but unless he or she has agreed to represent you and, you know, signed a contract, you know, that's it. And in our workshop sort of model too, the applicant, after talking with the attorney, the applicant goes to sort of a last steps where the Turk people tell them what they need to do to put the application together, where they need to file it, what they should expect, and that sort of thing. Yeah.
I speak Spanish. Can I be my own interpreter, or do I need another interpreter?
That is a subject of a lot of debate, actually more in the context of translations. I think interpreting, you know, when you're actually working with the applicant is fine. But Adrian mentioned, like, if you're going to submit a document in another language, you need a translation of it. Some attorneys do their own translations, and some don't feel comfortable doing it. I speak Spanish too, and I've done translations for clients, but I guess ideally you would have somebody else do it. And Adrian mentioned one of our partners in the collaboration, Conexión Américas, is about to pilot a service where they'll translate Spanish language birth certificates for $10, which is an amazing fee when you look at the long form birth certificate sometimes. Immigration used to allow you to do just sort of a extract of the birth certificate that just said, you know, name, date, place of birth, mother, father, but now they want the whole thing translated. So we hope that's going to be a good resource. All right, so you file along with the I-765, the I-765 worksheet. We have a slide on that. And it's just a simple form where the applicant has a chance to demonstrate economic necessity to immigration. That's the basis on which immigration will grant a work permit to the applicant. So in Part 2, financial information, you're going to put the applicant's income. And for a lot of people who are students, that'll be 0, and that's completely fine. One question you might get frequently is a lot of people think that if they have a work permit, this is in the renewal context, they're obligated to work. Nobody's obligated to work, they just have the right to work. So, you know, if somebody seems reticent to put down 0 income, you can reassure them that it's okay. You know, there are a lot of reasons that you're not working or may not be working. Current annual expenses, again, those are the expenses of the applicant. A lot of the time, you know, if you have a 16-year-old kid who's living at home, he or she may not know what his expenses are. And what we do is get the household expenses from the parent and then divide that by the number of people living in the house and use that as a gauge to say what the expenses for the applicant are. Total current value of assets, that's typically not a factor, but it's things like cars, houses, mobile homes, you know, anything like that. Most, particularly the kids, don't have any assets, and again, 0 is fine. And then Part 3, the applicant has a chance to tell immigration why he or she wants a work permit, and you know, it's a little bit different for every person, but it's typically some variation of, I'm in school, I'm in high school, and when I graduate, I'd like to go to college, and I'm saving for my education, or I'd like to help my family pay bills, or I have a daughter, and I'm the wage earner in the family. So whatever, just sort of something to make the applicant a little, you know, more 3D, a little fuller human being. Doesn't have to be long, you know, maybe 3 or 4 sentences. So, any questions on that, on the worksheet?
I would just add, I think there's a statement on there that you can submit documentation if you want
Yes.
to. I have never submitted any documentation along with that worksheet because they don't tell us what they might be looking for, and I've never had them ask for it. So just that brief statement and the
Yeah.
numbers have been sufficient.
And I think that requirement that the applicant demonstrate economic necessity is a pretty low bar. You know, most everybody needs to eat and have a roof over their head, and I think that immigration. Have you ever had anybody?
I haven't had one approved for deferred action for the protection, but not the work permit. So
You have or you have not?
Our client
Yeah.
population are low income. We do have a
Yeah.
restriction on our services. So there may be somebody out there who hasn't had that experience, but I haven't had anyone get deferred action, but not the work permit.
Okay. So those are the 3 forms that you'll file, and then we also talked briefly about the G28. So I'll pull that up really quickly. If you represent a client outside of the workshop setting, you'll need to file a G28, and that's in your folder as well. And there's nothing tricky, I don't think, about this. You know, it's just your information for state bar number. If anybody is admitted to practice in more than one state, you're supposed to include all the jurisdictions you're admitted to practice in. And then on page 2 of the G28, under additional information, you can indicate what your bar numbers are in the other jurisdictions where you're admitted to practice. So back to page 1 on part 2, you just need to indicate that you're an attorney eligible to practice law and that you're not subject to any order or any court administrative agency disbarring, et cetera, et cetera. Immigration does allow, they have a process for BIA representatives, so if you get certain training, you can act essentially as an immigration attorney. So There's that option under 2, and then also there's an option for law students. Page 2 of that form, Part 3, Question 1, you're going to list the form numbers you're filing. So I keep referring to those forms as 3 forms. There you're actually going to just list the I-821D and the I-765. The 765 worksheet is really part of the 765 application. Then you're going to put the applicant's name and then mailing address, and you as the attorney sign under Part 4. The applicant signs Part 3, Question 8, and then you sign in Part 4. And again, that you only need to do a G28 if you're representing the DACA applicant in your own capacity and not in a workshop setting.
I would add to that, if you do file a G28, then you are the attorney of record unless you withdraw that representation. That means you're going to get a copy of all the notices that the applicant's receiving. If they did get a request for evidence in RFE in that case, that generally only goes to the attorney. So you would need to be able to continue to find that applicant to respond to any RFEs that did come in on the case.
All right, so any question about that? Nope. So also in your training material packets, we've included a document checklist to help when you're putting the package together. It looks like this, and the first category is forms. Those are the 3 I-821, I-765, and I-765 worksheet. Every application has to have a filing fee of $465. For a lot of immigration remedies, there is a fee waiver. The fee waivers available under DACA are very, very limited. And the process is such that if you think you might qualify for a fee waiver, you have to apply for the fee waiver first. Is that right? Yeah, you have to apply for the fee waiver first and have that waiver approved before you apply for DACA. So I would guess most everybody you're working with would have to have that check or money order for $465. 2 passport-style photos, and then documents to establish each requirement that Adrian went through. And I was just going to go back for a second to the identity document. Most everyone has a passport, and we see a ton of Mexican citizens, and Mexico has a mobile consulate that comes to Nashville and provides pretty easy access for getting passports. So that's always my preference, is to send a passport, because if you send a birth certificate, you're disclosing more information about the applicant, you're disclosing parents' names, and even though immigration has said they're not going to use that information for enforcement purposes, it's just easier if all you have to send is the passport. And you also don't have to do a translation, which sort of saves you a step as well. So that's the checklist, and we put this together for in our workshop model. The community, the non-attorney volunteer fills out the application and also assembles the documents, and we put this together as just sort of an assist for them when they're looking through. You know, people come in with a stack of documents and they're looking through and trying to put things in order, just so they can go through and check off, you know, I have a document that shows that this person was here for each quarter of the year. All right, and then the last page is your very own copy of the immigration's sample work permit for you to reference. Oh, we have on the slide the fee exemptions. So you can see these are limited circumstances. You're eligible for a fee exemption if you're under 18 and homeless, 150% or less of the poverty line, plus you're in foster care, unable to care for yourself because of serious chronic disability, or $10,000 in debt incurred in the last 12 months because of unreimbursed medical expenses. All right, so that's the package. And let me just back up a step, and we'll talk very quickly about the renewal application. So if you go back to the I-821D, for renewal, you're going to file the same 3 forms, I-821D, I-765, and I-765 worksheet. But on Part 1 of the I-821D, you're going to check initial request. And then where it asks for my most recent period of deferred action expires on, that's the same date as the expiration date on the work permit. So if you have somebody who's renewing, they should come in with their actual work permit, and you can look on that to get the date of expiration of DACA. See, the rest of that is the same. Page 2, if they're a renewal applicant, they will have an A number and a social security number, so make sure you fill that piece in. Part 2, addresses for renewal applications, they only have to include those addresses where they've lived since they applied for DACA the first time. So that is a far simpler exercise, and a lot of people are still living in the same place they were living when they applied for DACA. Let's see, travel information, same as for an initial request. Part 3, you don't have to answer at all on renewal request. You can skip that whole part. Part 4 is the same as on initial request, as is the rest of the form. Okay? I didn't. Yeah. So we've talked a lot about page 7, where you can add additional information if you had to provide additional addresses on an initial application or criminal information. There's a signature box that's easy to miss on the bottom right-hand side. That's for the applicant. They need to sign and date. And that's true even if you don't put any additional information. Okay, everybody needs to sign that page, no matter what. All right, so the qualifications to be able to renew for DACA are the same. They have to continue to meet the initial qualifications, and including the criminal requirements, not having a significant criminal record, and not posing a threat to public safety. The immigration guidelines for processing renewals are shorter. They're targeting 4 months for renewal applications, and for initial applications, they're targeting 6 months. And we've seen a real variety, and I'm not sure we know really what the pattern is. Some people's applications come back much quicker, and some applications take a little longer. But those are the sort of general immigration target processing times. Immigration is recommending that people who are applying to renew DACA apply at least between 120 and 150 days before their current DACA grant expires. And the reason for that is that, the reason you want to make sure that the applicant does that is because immigration has said that if you apply during that window, that we will consider your deferred action extended if you don't get your new grant after your old grant expires. But as a practical matter, are they actually doing that yet?
So what they had said was they were considering providing a short-term extension. They
Right.
have not given us any mechanism for requesting that or indication that it's automatic. So up till this point, it hasn't been an issue for any clients. They've received the renewals before the expiration date. But I haven't seen an update on that particular issue.
So I think as a practical matter, our advice is apply in that window, if at all possible. That's the safest way to do it. But they're allowed to apply up to a full year after the DACA grant expires. So if you have DACA that expires today, you could apply January 28th, as long as it got there, I guess, January 28th, 2016. Okay. Did you have a question?
For renewals, do you have to submit the same packet of materials?
No, that's a very good question. So you have to submit the 3 forms, but you don't have to submit the documentation. Immigration has said that for renewal applications, the only documentation they want is documentation regarding crimes or immigration issues not submitted in connection with the initial application. So if everything was correct in the initial application, the only documents they should have to submit are anything that happened after their first application. For example, a lot of people were in high school when they applied the first time, and now they've graduated, and so they come back and they say, oh, do I need to submit my high school diploma? Immigration doesn't want it. It's really just those 2 categories.
And no
of
proof
documents.
of presence in the US.
No proof of continued presence.
I think they say that they reserve the right to ask for proof that you continue to meet all those requirements. I haven't had them ask for it for any of the renewal
Yeah.
applications.
Oh, on the slide, there's a link to the calculator for the National Immigration Law Center that if you, just want to make sure that you have the window exactly right, the 120 to 150 day window, you can put the date of expiration of the current work permit and it will tell you exactly the dates that the person should reapply. The I-765 has a couple of things that are different for renewals. Starting with question 1, instead of saying I'm seeking permission to accept employment, you're going to check the third box. I'm applying for renewal of my permission to accept employment. And then when you get down to question 9, the applicant should have a social security number, should have an A number, and question 11, the answer should be yes. And again, you'll go to the work permit and figure out which office issued the work permit, the date it was issued, and you will put granted. And I think that's the only difference. And then the I-765 worksheet is the same for the initial application and the renewal application. Yeah.
Do these applicants go through a process to let them know what documents they need to bring with them? Or is there a lot of, they come and you have to turn them away because they didn't bring?
Yes, to both of those questions. So when they call to make an appointment, they're given a list. They go through a screening to make sure they meet the requirements, and then they're given a list of what they need to bring. And a lot of the time, they have everything and it's perfect. Sometimes they don't. Sometimes they haven't quite understood like the continuous presence requirement, so they don't have quite enough to prove that they've been here. Or I guess, like Adrian said, probably the hardest one for people to find is showing physical presence on June 15th, 2012. But for school-age applicants, that's a lot easier. For applicants who are a little bit older, it's more difficult. But, I found for older applicants, sometimes they have records for their children, like their children went to a doctor, or, as Adrian said, if you can somehow connect what the child was doing to the parent's presence, you can do that. So they come to the workshop, we think, knowing more or less what they need, but it's not always a perfect system. And in fact, sometimes, like anything in life, it depends on how you ask the question. I worked at a citizenship workshop recently, and there was a guy who'd been through the pre-screening, he'd been through 3 or 4 volunteers, and he got to the attorney volunteer sitting next to me, and he said, I have this conviction for aggravated assault. Is that a problem? And he'd never mentioned it to anybody. They'd done all his paperwork, and he was kind of like, I just feel like I have a rapport with you, and, I wanted to let you know that. So it's not perfect. Sometimes, you just have to work with people. And typically in that situation, we'll give them something like that document checklist and write specifically, you need, come back, you need to bring this with you. Okay, once the application is put together and filed, if it's in a workshop, the applicant is going to do it by himself or by herself. The next thing that happens is the applicant will get a notice from immigration saying, we have your application and we're reviewing it. A couple of weeks after that, they'll get a notice for an appointment to have their fingerprints taken, and that's at a place out by the airport. And they'll have to go with the notice of appointment and some sort of, their passport is the ideal, some sort of government-issued photo ID. And then after they have their fingerprints taken, immigration will do a background check, and then the file will go to the immigration officer that's doing the review. And then that waiting period happens. And during that waiting period is when the applicant might get a request for evidence. And again, we're talking about sort of 2 situations. If it's a workshop situation and the applicant's not represented by an attorney, the request for evidence will go to the applicant. If you filed a G-28 in the case, the request for evidence will always come to you. The request for evidence doesn't necessarily mean the applicant's not going to get deferred action. It often just means immigration wants to fill in the gaps or wants some more information about a question that came up. Again, cases are adjudicated case-by-case basis. Even if somebody meets all the requirements for DACA, it's a discretionary decision, so immigration reserves the right to, for whatever reason that they deem appropriate, to deny a DACA applicant. There's no interview. And then after biometrics, you either get a request for evidence or you'll get an approval, or a request for evidence and then an approval. I think if they're going to deny, you get a notice of intent to deny. So-
If you get an RFE and they don't consider the response adequate, you don't get a notice of intent to deny again.
They just deny you.
Yeah, so
Okay.
I haven't gotten a notice of intent to deny. Even if the immigration officer doesn't believe you have enough information to be approved, you would receive a notice of intent to deny with the opportunity to supplement the information that had already been submitted. So you generally get two shots.
Yeah.
Whether or not they just want a little more evidence or they want a lot of evidence would determine which of those forms that second request would take.
All right. As Adrian said, the deferred action grant and work permits are now valid for 3 years. There's not an appeal process for DACA except in very limited circumstances. And those are they've changed recently, and they're in the FAQs on immigration website. So among the reasons you can request a review of denial, let's see. So if the applicant can prove that he or she responded to the RFE within the required time, or that the RFE was sent to the wrong address. For example, if the applicant applied using one mailing address and then submitted a change of address form to immigration, but that didn't make it to the right place, and immigration sent the request for evidence to the original address, if you can establish that, then that's a basis for asking for a review. And actually, I should make that an important point. This is one of the things that we say over and over again to applicants, is to make sure that they keep their address current with immigration, because immigration will treat whatever they have as the correct address. And we've actually had clients who moved but didn't notify immigration, so immigration sent the approved DACA and approved work permit to the address they had on file, and as far as they were done, that was it. They were concerned that was it. They'd taken care, and so that costs the applicant another $465 to get that replaced. It's easy to change your address with immigration. You can do it online, or you can file an AR-11, which is a form that you print out just like one of these forms. And I know that we're talking, for people who don't do immigration work, we're talking in all these numbers. If you go to the immigration website and you use the term change of address or attorney representation, you'll come up with the right document. All right.
Translations, do you put a certificate of translation with notarized, and is all that? I know you said you might have a service available at these. But
Yes.
Like I could reach over and have Erica translate something for me maybe, and then she would just sign that certificate.
Right, and immigration has specific language that they recommend, and it's something along the lines of, I certify that I am, I can't remember if it's competent or fluent. I'm competent in English and Spanish, and this is a true and accurate translation. It's not, it doesn't have to be notarized. It doesn't. No. No, it's pretty straightforward. All right, and then we talked about decision. Oh, I know what I was going to say. Appeals or reviews aren't widely available, but denial of DACA is without prejudice. So if you have an applicant that gets denied and they think they can rectify the basis for the denial, they didn't do it in the original process, but they think they can do it if they reapply, they can reapply, spend another $465 and apply again. All right, and I think I'm handing it back. Oh, sure. Yeah, okay. So this is, the risk and responsibility is a document that I was talking about that we have attorneys at workshops go over with the applicants. You'll see divided into pretty simple categories. Understand what you're applying for. This one actually was, I guess, printed before November, so it says 2 years. So you're you're asking immigration for a decision not to remove you for 2 years, but now it's 3 years. That it's not lawful status. It doesn't give them any sort of lawful immigration status. but immigration won't pursue deportation or removal. It's not a path to green card or citizenship, and they'll nod their heads when you say this, but still, you know, say it, because there's a lot of misinformation about that. Let's see. Again, there's some aspects of immigration law where you apply for a family-based immigration status, for example, and you have to leave the country or not in order to qualify, but DACA is not something that you can use to springboard into any sort of immigration status. And then the benefits of DACA, that if you show financial need, you can get a work permit and a social security number, and in Tennessee that means you can obtain a driver's license. And I'll make my pitch here for right now in Tennessee. This differs state by state, but the law in Tennessee is that DACA recipients, while they can apply to go to college, they aren't eligible for any federal funding, any loan funding, and that also, and they're not eligible for in-state tuition, and they're also not eligible for the new Tennessee Promise, the 2 free years of community college that Governor Haslam has announced. So Turk, our partner organization, is an advocacy group that's lobbying on this issue. So if anybody has a particular interest in that, get in touch with Turk. They're trying to put another bill in front of the legislature this session to address that. Because being able to apply to school is different than being able to pay to go to school. The risks are pretty extensive. So this is the piece that Adrian talked about, where immigration said that the information provided won't be shared for enforcement purposes, except in certain situations, fraud, if you committed serious crime, national security, and they're investigating or prosecuting a criminal offense. And they have very often restated their right to change that position at any point too. So it's important that when you're talking to DACA applicants, that they understand that this is not a law passed by Congress, and what immigration is saying now, all of it can change at any point. So additional risk, or just you talk about that it's a discretionary decision. You may reveal information that if there's some other type of immigration relief available to you under a future law, that it may impact the information you reveal in your DACA application may impact that relief. The specific risk of immigration starting a removal case about somebody who makes misrepresentation or fails to disclose in a DACA application. That goes back to the criminal questions. It's, again, ask the questions over, and even though the applicant has been through the process, when they get to you, talk to them about, have you ever been arrested for a crime? Have you ever been pulled over? Have you ever been in a police car? Have you ever been in jail? Just to make sure, because it is a discretionary decision. If somebody qualifies for DACA, but has a sort of questionable criminal issue, that may be a person that shouldn't pursue DACA. There's a decision to be made about whether it's worth the risk of disclosing things. And I always say to people too, immigration's going to run a criminal background check. That's what the fingerprints are about. So let's make sure we're full and complete. The last bullet point is about if you've been involved in conduct, and I think this really that didn't result in arrest or charge or conviction, and I think this really has a lot to do with national security issues and gang membership issues, which are priorities for deportation, for immigration. On the next page is the piece about understand your responsibilities. You're an advice-only legal clinic. I think this is to your question. The attorney that you talked to today is not representing you except in this particular setting, and that what the applicant's responsibility is, and then a little bit about the process. There's a piece at the end too that explains when you're eligible to renew your DACA grant, and why you want to renew within that window. The last piece, understand your rights at this clinic. Sometimes we get kids who are with their parents are with them for the application process, but maybe they're not comfortable talking about something that happened in front of their parents. So in that situation, I often ask the kid if he or she wants to, talk to me by himself. I always offer that option. And just, sort of typical confidentiality representation. Then on the back of that are some resources for applicants, but also for you guys. So the reference to frequently asked questions and all the forms, the renewal calculator. Own the Dream is an organization about just over halfway down. Own the Dream is an organization that has a really fantastic web-based and smartphone app that helps people who think they might be eligible for DACA sort of go through a screening. Do you have a question?
Yeah, more in a long-term sense, looking forward for the people who are applying for this. You've said that it doesn't provide a path to a green card or citizenship, but can someone who receives a DACA authorization then at a later point get an employer-sponsored visa or something like that?
Yes. There's no holding DACA doesn't preclude you from pursuing any other immigration relief. And in fact, one of the types of cases that Adrian handles a lot is a U visa case, and that's a visa created specifically for victims of crime, certain kinds of very serious crimes, who have assisted law enforcement in the prosecution of the crime. And sometimes, because that's sort of a lengthy process, sometimes we'll have clients that apply for DACA and U visa concurrently.
And so the fact that they're going to disclose that they've been in the United States unlawfully for at least 5 years won't harm them in, say, an employer-sponsored visa petition later on?
So, being present in the United States without lawful presence, and then leaving can create a ground of inadmissibility that would affect a person's ability to actually obtain immigration status through a family member, through an employer, something like that. You don't start accruing unlawful presence until you turn 18 in most circumstances. So a DACA applicant, for instance, who applies before they turn 18, DACA will stop the accrual of that unlawful presence. So they may never have any unlawful presence in the United States. Now, when you're going through the family-based process, if you meet certain requirements, you can do the whole process in the United States. Other people have to leave the country and process through the consulate in their country of citizenship. And that's when they trigger that ground of inadmissibility after having lived here without lawful status for a certain amount of time. So if you've lived here for a year or longer and you leave, it creates a bar to reentering for 10 years. So there are a lot of people who potentially could apply through a family member who aren't pursuing that option because the process is so difficult. So DACA is not going to cure that for everyone, but for somebody who receives the grant before they turn 18, never accrues any unlawful presence, it may allow them to, in the future, pursue a family-based process, for instance, without triggering that 10-year bar if they do have to leave the country. So it totally depends on what other form of relief they're eligible for. But that's one of the reasons that we talk to them seriously, is because if they are saying, I've been here since 2007, that could potentially affect, if they're over 18, for instance, that could potentially affect what the process might look like for another form of immigration relief in the future.
Are
Yes.
these applications subject to FOIA requests?
Yes, I believe so, yeah. And in fact, we had a conversation about somebody recently. So when I work with somebody who's doing a renewal application, in the ideal world, you have a copy of their initial application, because you want to make sure everything you say in the renewal is what was said in the initial application. It's not always perfect, but we talked about trying to FOIA in a particular situation an initial application first before resubmitting. It takes, like all FOIA requests, a long time. Yeah. If you have an A number, I think you said it's a little faster. Yeah. Yeah.
And if you're looking
Yeah.
for a very specific thing, it hopefully wouldn't be
Yeah.
8 months, but
Yeah.
it still could take
Yeah.
a while before you get the result.
How much success have you had
In
in these DACA applications?
So Bethany started so recently.
she hasn't had any go all the way through the process yet that she's actually filed in our office. I have had one denied because the applicant committed a crime in between the time that we filed and the time that they made a decision. And other than that, we filed, received results in 2014 in close to 100 cases, and they were approved. So.
But also, when DACA was first announced in 2012, Adrian and Kaki, who was here earlier, you guys must have done hundreds of applications then. But I guess you didn't know because you weren't filing G28s.
We have heard, I was telling Janelle earlier, we've heard back from a lot of clients, or a number of clients who did go through the workshops in 2012 who are now ready to renew, but we didn't have a formal system for tracking those applications through the process.
Yeah.
So they don't use the discretion to deny indiscriminately?
No, if a case is going to be denied, it's reviewed by a supervisor. So you can be fairly certain that there's consistency in the adjudication process, and we haven't seen that eligible candidates are being denied for no reason by any.
It seems like the criminal issues are the most sort of complicated things that come up, and a lot of the applicants that I've seen have been, so far have been super straightforward. Great kids, they're in school, they're doing all the right things, and I think you wouldn't see a negative exercise of discretion in that situation. Yeah.
Is there any other written authority, like any additional memorandums from DHS other than the ones that are in our packets? Because I'm wondering where the definition of like a non-significant misdemeanor comes from.
Sorry, I don't. The good thing about DACA is it's all the information that anybody has is pretty much in one place. So if you go to the USCIS website, and it used to be on the front page, I don't think it is anymore, but just put DACA into the search bar. There'll be, the first thing that will come up will be the basically just the eligibility requirements, and it goes through in detail what they're looking for and how you can demonstrate that. And then within that page is a link to frequently asked questions that goes in depth into a lot of the kinds of questions that we're talking about today. I think the definition of a significant misdemeanor and
It does.
purposes for travel, when you can ask for review. So it's like 7 or 8 pages of frequently asked questions, and it's got a lot of really great information. And you've got the link, I think, in the back of the page. Is that right?
Yeah, on the back of risk and responsibilities at the top, it's there. Okay. And that, it's really well indexed. It's very easy. Like if you have a criminal question, you can, just skip down the page to the criminal question. All right, any other questions? I'm going to turn it back over to Adrian then for the last piece.
Done with this yet, but there's still a little bit.
Sorry, I've got just a couple. Okay, I just wanted to highlight a couple of the frequently asked questions that I get from applicants. So again, just to highlight one more time, the information that's disclosed as part of the DACA application is protected from disclosure relating to immigration enforcement, except if the person is a priority for removal. It can be shared for other purposes. Applicants' family members, any parent's name that appears in the application, for instance, have that same protection, but that policy could be modified, superseded, or rescinded at any time. That has been the policy since the program started. It is the policy today, but we don't have a guarantee that will always be the policy regarding the information shared as part of the process. If anybody does knowingly make a misrepresentation or commit fraud in the application, they would be treated as an immigration enforcement priority. So it's very important that the applicant is disclosing any relevant information as part of the process. If they have a criminal history, or they've been arrested, or they've had contact with law enforcement, but they don't know the details, there are some ways they can find that out. If it was in Davidson County, the criminal court clerk's office has a really great website where you can do a name-based search to find out information about a person's criminal history. You can also do an FBI fingerprint-based background search that should come up with any times that law enforcement, including immigration enforcement, has fingerprinted the applicant. And we are working on figuring out a process to do the fingerprinting so that people can send those cards to the FBI for that background check. If they know that they've had some contact with law enforcement but they don't know the details of that, that would be one way that they could find that out, because they want to make sure that they are disclosing anything that's necessary to the Immigration Service as part of this application. So frequently asked questions, the USCIS frequently asked questions are available at uscis.gov, and that's a really good place to get information about the kind of the nitty-gritty as far as the details of applying for the application, for applying for DACA, what the Immigration Service is looking for, and they update it as people are having the same issues. For instance, the question of whether to include a social security number that wasn't issued by the government is addressed there. And they added that after that question came up a lot from practitioners. So, so those are updated fairly regularly as questions come up, and they're a really good place to get information as you're working through the process with somebody. Frequently asked questions that I get from applicants include, can I travel with DACA? The answer is in certain circumstances. So a person, once they've received DACA, can apply for advanced parole, permission to leave the United States on a temporary basis if that travel is for educational, employment, or humanitarian purposes. The example that the Immigration Service gives for humanitarian purpose is to visit a sick or elderly relative, but there may be other situations that would fit in that category. You can't apply for that travel permission until after you have your DACA approval in hand, and it does require a separate form with a separate fee in order to make that application. Any DACA applicant who has a removal order or has been previously deported would need to talk with an immigration attorney before applying for that permission to travel, in case that would have additional consequences for them. So if somebody's in that situation, then they should talk with an immigration attorney before they apply for any permission to leave the United States, or certainly before they actually leave the United States. Does DACA lead to my green card or to U.S. citizenship? So this, as Bethany said, you know, as many times as we tell applicants, this is a form of temporary protection. It gives you work authorization under the law today. That's all that it gives you. There is still a lot of misunderstanding out there that if once I renew, well, then next time I'm going to be ready to apply for my green card, or in 5 years I'm going to be ready to apply for my green card. So when you're working with an applicant, it's really helpful to make sure that they truly understand under the law today, the DACA program doesn't lead to a green card. Our hope is that with comprehensive immigration reform, there may be a path to permanent residence for people who meet these DACA requirements, but we don't know for sure when or if that's going to happen. Can I apply to college with DACA? So having a social security number does likely make it a little easier to apply to certain institutions. There are some schools that accept students who are undocumented with no social. There are additional institutions that can accept a student who has a social security number under the DACA program. As Bethany mentioned, they would not qualify for federal student aid or state aid, including in-state tuition. But Turk and other advocacy organizations are working hopefully to change that. Can I get health insurance through the Affordable Care Act with DACA? The answer to that question is no. DACA recipient is not eligible to apply for insurance through the ACA. Okay, so now for a quick review of the basic requirements. How old you have to have entered the United States before what age to qualify for DACA? 16? Yeah, oop, okay. How old must you, or what age can you not have reached as of June 15, 2012? 31, very good. How old do you have to be at the time of the request for most people? At least 15, except if you're in removal proceedings or have a final order of deportation. What day do you have to show that you are physically present in the United States on? June 15th, 2012, and at the time that you're making the request. That's going to be also true as far as your immigration status. You cannot have had a lawful immigration status as of that day. When does the continuous residence requirement start under the current program?
June 15, 2007.
Okay, and how about under the expanded program? Very good. And then the education and military requirements we've gone over, either in school, have graduated, have received your GED, or have performed honorable military service. Okay, sorry. I had a few other slides that don't appear to have shown up again. This happened to us last time, and I thought it was fixed. But I just wanted to talk very briefly about the executive actions that, that the President announced on November 20th, just so you know kind of what's coming down the pipe. So on the 20th, the President announced a few changes to the immigration system, two of which have gotten kind of the most buzz, but there are a few others. One of those is the Deferred Action for Parental Accountability, or DAPA program. One is the expansion of the DACA program to include more individuals. He also expanded the use of provisional waivers, which make it easier for certain family members of U.S. citizens or permanent residents to go through that family-based process. He ended the Secure Communities program and redefined immigration enforcement priorities. So even for people who don't have a way to affirmatively apply for any sort of immigration relief at this time, those change priorities are kind of focusing ICE resources on certain groups, including people who've committed serious crimes that may help make enforcement less of a risk for other populations. He announced some changes to the employment-based immigration system and plans to promote citizenship to permanent residents. So the Deferred Action for Parental Accountability program, that application is supposed to be available starting May 20th of this year. It would require the person to demonstrate continuous residence in the United States since at least January 1st, 2010, just like the expanded DACA program. They would have to show that they are the parent of a United States citizen or a lawful permanent resident who was born on or before November 20th of 2014, and they'd have to show that they're not an enforcement priority for removal from the United States. And those enforcement priorities look they're going to look very familiar to people who are working within the DACA program, because they are people who've committed felonies, significant misdemeanors, 3 or more non-significant misdemeanors, or the other category are people subject to recent removal orders. So to qualify for that DAPA program, you wouldn't want to, you couldn't fall into any of those categories. And then the expansion of DACA is supposed to become available February 20th, 2015. Again, as we kind of talked about at the beginning of today, there are challenges to that program, to these programs, that may delay that start date. But the idea is that this expanded group of applicants will be eligible to apply starting February 20th. It removes the age cap of under 31 as of June 15th, 2012. It requires continuous residence in the United States since January 1st, 2010 instead of June 15th, 2007. And one thing that already has gone into effect is it does extend the period of deferred action from 2 years to 3 years. So anybody whose application was pending as of November 20th has received a grant of 3 years instead of the 2 years they originally got. So for people who had already applied, that was a happy surprise. For everyone else, they're going to get a little bit more bang for their buck as they're applying to renew DACA. So they would have gotten 2 years originally. People who are renewing now will get the 3-year grant instead. Does anyone have any questions about anything right now? Yes?
How many opportunities does one get to renew?
Right now, the program is indefinite. You can renew every 2 years or now every 3 years on an ongoing basis. Because it's an administrative program, it is subject to change when the president changes or if the president were to change his mind. But the Immigration Service is planning on being able to renew indefinitely. Sorry?
Of the 30? The 31 years or 30 years?
Oh, no. So the age cap actually only, so long as you were under 31 as of the date that the program was announced, even if you turned 31 the next day, you could continue to qualify. So now that there was never, so long as you met it at that date, you weren't prevented from continuing to renew. So now that the age cap will be gone, there'll be that additional group of people who can apply. But it wasn't an age cap in that sense, that you had to be under 30 to qualify, or under 31 to qualify. Any other, yes?
So one of the stated goals for this is to promote citizenship, and obviously some people are going to have family ties to U.S. citizens, but for those who maybe don't, or their relatives are permanent, are lawful residents, is there a path laid out for that already, or?
For someone who's related to a U.S. citizen or permanent resident? So yes, so the traditional family-based program is still available, and if you qualify for DACA and also could qualify to apply through another family member, having DACA is not going to prevent you from pursuing that. There are a lot of people who haven't pursued those family-based options because of the way the process works. If they're required to leave the country and trigger a barrier to re-entering for a decade, that may not be worth it. So DACA doesn't cure those issues for a lot of people, even if they qualify for that and a family-based form of relief. We are, as part of this program, screening people for better forms of relief than DACA, because we want to make sure if somebody maybe could qualify for a U visa or could qualify through a family member, that they're at least aware of those options. So we are trying to make sure that that all the different options they may have are communicated to them, but having DACA is not gonna prevent you from applying for something else if you qualify for it in the future. Any other questions about anything for right now? So I believe you have information about our upcoming workshops in your folder. I'll hand it back over to Bethany for that.
So we have a very ambitious workshop schedule. Our goal is to reach 2,000 people apply for the DACA for the first time or to renew in this calendar year. So I've got everybody's email addresses. I'm going to be emailing workshops as we get them scheduled. You have in your materials on the left side some dates in February when we're having workshops, but we appreciate your coming today. Thank you for your interest, and we would love to have you help at a workshop.
For any attorneys who want CLE credit, if you can be sure to fill out your form and return it at the front desk. And then there's also a feedback form if there's anything you think we could do better, or if you were thrilled, we'd love to know that as well. That would help us out. And otherwise, we look forward to seeing you at a workshop.
We have a box top out in the